Why would it be good if more lawyers were familiar with the work of H.W. Fowler?
Oh, well, he is so good at conveying very subtle differences in words. And there are subtle differences. Some people don't appreciate them. Fowler will almost always tell you just what they are. There's one word that I'm thinking of.
How about masterly versus masterful? Is that what you care about?
Masterly versus masterful.
Masterful being domineering and a little bit bullying. Masterly being
You see, now there's one that went right by me. Now that you've told me, I will use them properly, because it's useful to have that distinction, isn't it? It's useful to have that. I know what I was groping for. Susceptible. There's a difference between susceptible to and susceptible of. And someone who's sensitive to English understands that difference. You're susceptible to something if you're vulnerable to it. He's susceptible to colds or something like that. You're susceptible of something if you have the capacity to enjoy it, or it is susceptible of further discussion, or susceptible of more precise expression, or something like that. It's quite different from being vulnerable. And the proper use of English conveys those differences.
You are very persnickety.
But when you're talking about people who write constantly, and I read these briefs all the time, cite to, we're light years away from those subtleties.
Right. You're very persnickety in your opinions about hyphenating phrasal adjectives. Why is that an important thing to do?
Oh, well, I was on the Harvard Law Review in the days when we had a blue book that was taken very seriously. And we had things called the unit modifier rule. It is a rule that really does make a lot of sense. And the example we always used to use was the purple people eater. If it's a purple eater of people, you would write it purple people -eater, right? And the reader would understand that, a purple people eater. On the other hand, if it was an eater of purple people, the hyphen would be moved over, purple people eater. It helps comprehension, and anything that helps comprehension should be embraced.
Do you agree that our literary heritage in law has, with just a few notable exceptions, been pretty shabby?
Maybe, yes. I think that's probably right. There are not many great stylists.
Isn't that odd, though, that lawyers are the highest paid professional writers in the world as a class?
What can I tell you? Maybe judges aren't. It is. Marshall certainly wrote beautifully, and most of his generation did. I think it's in later years that we've adopted cant and legalese. I really think that's come in more recently.
If you exclude the present justices, who are the best writers ever to serve in the Supreme Court?
Oh, the only one that I really admire enormously is Robert Jackson. He was a wonderful writer. Had flow, vividness. He could make a point with such force. A wonderful writer.
Jackson was considered, I know that there's an ABA piece from the late 1940s, early 50s. He was considered to be way too aggressive toward his colleagues in his dissents.
Oh, imagine that.
Have you ever noted those criticisms of Jackson?
I didn't realize that. No, I did not realize that. He had hard-hitting dissents, and where hard-hitting is called for, Maybe that's why I like them, I don't know.
Why are good dissents so much more interesting than majority opinions?
Well, partly because they can be more the expression of the man or woman who writes them. You don't have to get permission from somebody else to put in a vivid metaphor or something like that. It's up to you. Whereas in a majority opinion, you have to often take out portions or phrases that other people don't want to include. A good opinion has personality. And it's easier to have personality when you're writing for yourself. Somebody can join your dissent if they want to, but you're not obliged, as you are when you're writing the majority opinion, to come up with something that everybody can go along with.
Is the court trying to become less splintered in its opinions?
No, it's not trying any harder than it ever did. I mean, we've always tried to avoid splintered opinions. At least to this extent, that there is always one opinion for the court. 5 justices signing on to one opinion, so that the bar knows what the lesson of the case is. After that, I can't really say that the court has tried in the past, or even tries today, to suppress, once you have the 5 on one opinion, if other people want to write separate concurrences or dissents, who cares? You know which opinion is the opinion for the court, and you just don't have to read the concurrences or dissents. I happen to be of the old-fashioned view that a judge should not join any opinion that he does not believe is correct on not just the principal point, but on all the points of law that are set forth. And I have never joined an opinion that I did not think was entirely correct. And you can criticize me, therefore, not just for the opinions that I've written, but for the opinions that I've joined. I happen to think that approach not only conforms with our history. I mean, after all, we came out of a system in which each judge wrote his own separate opinion, so you knew what each judge thought. But I think it is also necessary in order to hold judges to account. You shouldn't be able to join an opinion that you don't really believe in, and then later write an opinion that contradicts that. You should be accusable of being inconsistent. So not every judge feels that way. Some feel that, if it's close enough for government work, just sign on to it.
Do you think you can say that dissenting opinions are any more valuable than concurrences?
I think they're more valuable in this respect. The concurring opinion somehow can preserve the integrity of the court. I mean, it's wonderful to go back to Karamazov and read Jackson. Read his dissent. You can say, well, at least somebody saw what was wrong here. Somebody saw it. A dissent has that value. Whereas a separate concurrence, I don't really like writing a separate concurrence, and I only write them to maintain my integrity. If I don't agree with the analysis in the majority, I should say so. I don't enjoy writing concurrences. I don't look forward to it.
Carl Llewellyn believed that for every canon of construction there's an equal but opposite exception. You don't agree with that, do you?
No, I thought that was really sort of a smart alecky article that Carl Llewellyn wrote. Nobody ever pretended that each one of the canons of construction is fully operative and gives you the answer. I wouldn't say that they contradict each other, but some of them point in different directions, but all of them are true. Sometimes one of them cuts this way with regard to a particular statute, and another one may cut the other way. And it's part of the job of a good judge and a good lawyer to know which should prevail in these circumstances. But that doesn't mean that they're worthless just because they do not always point in the same direction. I mean, gee, if you did that with predictions of weather, where you have different things pointing in different, of course, you still have to make the judgment as to what predominates.
What is the best use of law clerks at the Supreme Court?
Ooh. I think it depends on the judge. I think all judges probably use them in different fashions. I mean, I think they're essential for getting us through our cert petition work here. I mean, I couldn't possibly handle, we're doing twice as many cert petitions a year as we were doing when I first came on the court. And without the summaries of those that are prepared by law clerks, I couldn't get through 8,000 or 9,000 of them a year. In my chambers, at least, my law clerks are the principal people with whom I discuss a case. I don't discuss the case that much with my colleagues. You have one conference after the oral argument. That conference is not lengthy, where I really hone my view of the case is in discussions with my law clerks, each of whom should know the case 4 times better than I do, because each one of them is assigned just 1/4 of the cases. They know a little bit about the other ones, and I use my law clerks. Most of my opinions, my law clerk will write the first draft. I like to think that the last draft bears my stamp on it, and they write the first draft as they are instructed to write it. Do this, this, and this. But I find that it is simply more efficient to have the first draft drafted by a clerk.
How do you get?
Not always. Sometimes I do it myself.
Do you? How do you get the Scalia imprint on a clerk drafted opinion?
Well, I told you I go through 5 times. I go through it at least 5 times, and each time I put things in a slightly different way that seems to me a better way to make the point. I'll alter the order of presentation very often, shorten sections, lengthen sections.
Is there a significant downside to clerk drafted opinions? Not in your chambers, but generally.
Well, there's a significant downside if you don't work on them. I mean, if you just say, "Oh yeah," and let it go, it comes out the way I want it. It says basically what I want it to say. I think that is the downside, unless you go through it, painstakingly, and make sure that every sentence, every point says exactly what you think has to be said, no more, no less. Yeah, I guess it invites laziness. You could say, the law lords in England still don't have law clerks. They don't have a single. That every word that appears in one of their opinions was drafted by that justice, by that law lord. That's enormously inefficient, but it does assure that kind of hands-on judging.
I think they also have 2 secretaries among the 10 law lords.
Is that right?
It's extraordinary, isn't it?
Oh, I didn't realize that they had so few secretaries. No, it is, and as I say, I think it's inefficient. I think you can do a better job with assistance if you use it properly.